All the best, teams.
So, are we ready to proceed?
Yes.
Both teams ready? It falls to me to chair this final panel. And I gather each of you have had the details of all of the panel members. Is that correct?
Yes, sir.
So I won't take up time by introductions. We expect that you will proceed first with jurisdiction and then with merits, respondent leading on jurisdiction, claimant leading on merits, and that your submissions will be limited to 15 minutes, although you are welcome to ask for extensions should you wish to do so. We're going to ask our assistant organizer to keep the time for us, and you'll be advised of the timing appropriately, I think. Is that correct? Good. So how will that advice come to the team? How will the speakers know of the timing advice? Sorry, who of the organizers is going to do this for us?
I'm so sorry, sir.
Yeah, and how will you tell the teams of the timing?
So we'll drop it in the chat box.
Chat box. Is that satisfactory to each of you, team members?
Yes, sir.
Yes.
Okay. All right, so shall we proceed? First, a respondent on jurisdiction.
Before I proceed, I want to clarify if I'm audible clearly and visible. Thank you. Honorable members of the tribunal, esteemed colleagues, good afternoon from India. My name is Tanvi, and together with my co-counsel, Ms. Kavya Vela, we'll be addressing the respondent in today's proceedings. I will be addressing the procedural issues of the case, while my co-counsel shall address the merits of the dispute. We are before this tribunal today asking for you to refuse to relook at the purchase and supply agreement. The claimant has commenced this arbitration for breach of contract, although all communications on domestic pending corruption case against Mr. David Field, the COO of the Equatoriana Geoscience, were duly done. Additionally, claimant's misrepresentation of the Kestrel IA drones in relation to current technological standards of UAVs has led respondent to avoid the contract under Article 3.2.5 of the ICCA. Before my co-counsel, Ms. Virla, addresses the merits of this dispute regarding avoidance of PSA, there are two procedural issues that this tribunal should address. And in that vein, I have two submissions. First is that this tribunal should find that under the applicable law of Equatoriana, it has neither the jurisdiction nor capacity to adapt the contract. And second is that it should stay the proceedings until the investigations against Mr. Field have been concluded, or alternatively bifurcate the proceedings. Moving to my first submission. Under this particular tribunal lacks jurisdiction to hear the dispute on two grounds. Firstly, the PSA, Purchase and Supply Agreement, containing the arbitration clause in Article 20, constitutes an administrative contract that did not receive the requisite authorization by the Equatorian Parliament, and thus that the respondent had no capacity to enter into it. And second, that the issue of corruption leads to the invalidity of the contract. I shall deal with these two issues in three major points, starting with funding, purpose, and awareness. In the current case, I invite the tribunal to PO2 at question number 7 at page 44. Is the tribunal with me? Thank you. In the first sentence, it is mentioned that 25 million euros were the initial fundings given by the government and the state to the organization. In the second sentence, it mentions that usage of these other mechanisms of revenue accruation was done through exploration of natural resources and construction on infrastructure. These indicate that natural resources such as mining and otherwise were done as per the public service and meant for a public use. And the other revenue which the company has been accruing has also been directed towards the government. Data taken to another part development was also a public service because it was at the end of the day done for the mining and infrastructure. To add to this, I request the tribunal to also note that the citizen article at page number 33 is the tribunal with me? In the second row, determines that there was usage of medical equipments done also to remote areas of northern part of Equatoriana. Again, indicative that the public service was incurred through these usage of these drones. Therefore, while the contract was not directly impacting any government, it was meant to acquire drones, which at the end of the day helped the government and public organizations.
Mr. President, if I may interrupt and ask a question. Counsel, you haven't given us a definition of an administrative contract. You've pointed out that there were a government interest in this, but it seems to me that there's clearly a recognition of different types of contracts that government entities enter into, administrative and otherwise. So the mere fact that this involves government doesn't answer the question whether it's an administrative contract. Do you have a definition for us or a standard for us to apply?
Indeed, member. I request the tribunal to reach at question number 31 on PO2 at page number 47 and 48. It defines administrative contract for us. Is the tribunal with me? The administrative contract here is been referred to that of public works nature, and therefore this is a definition under Article 75 of the Equatorian Constitution. And therefore the understanding of usage of public funds and purpose of public nature indicates that the current contract, that is acquisition of drones, was primarily meant for this public work itself.
So do you have a definition for us of public works, or are you just telling us that anytime the government spends money on a contract, it automatically is an administrative contract? Because that seems like it sweeps very broadly.
There are two major things which we take into consideration for the same. The first is what was the public funding coming from, and second is the purpose of the contract. And this is the Black's Law Dictionary definition of administrative contract as well, and the public works as well. Apologies, Amber. Therefore, the definition of public works has been both funding and the purpose of the contract undertaken by the parties. Thank you, Member.
Thank you.
I've now invite the panel to move to page number 10, that is the purchase and supply agreement, which was signed between the parties. Is the tribunal with me? Thank you. The first sentence of the purchase and supply agreement, indicating the preamble of the agreement, indicates that it was initiated for the Northern Part Development Program, which is a state-based program meant for remote access. The second statement in the preamble indicates that it was founded to exploit and explore the natural resources. And the last sentence in the same preamble indicates that the agreement was always having to require approval of Minister of Natural Resources and Development. These sentences indicate a couple of things. Firstly, that the organization always had state interference and was meant for a state purpose. And secondly, that the claimant was aware throughout that the requirement of parliamentary approval is essentially important. To add to that, at page number 8, Exhibit C7, if the tribunal is with me, page number 18, apologies. Page number 18, Exhibit C7. It's the statement of Horatia Porter. Is the tribunal with me? In paragraph number 6, she has accepted that she was aware that this particular contract had public infrastructure, along with it, She also was aware that the ministry approval was essentially important for the tribunal, for the agreement to go ahead. These statements indicate that the parties were always aware that the requirement of ministerial approval was always essential. Therefore, Article 75 of the Equatorian Constitution is essentially important and invalidates the party. And to add to that, we shall now move to Article 2 and Article 5 of the New York Convention. The parties are signatories to New York Convention as per Procedural Order 1. Article 5, Clause 1 indicates that there's a recognition and enforcement of award in case of capability only, and in any other case, it will incapacitate the parties. Article 2 indicates that the incapacity shall make the contract inoperable and incapable. We are reading these two articles together as per the definition of carry bond in the International Commercial Arbitration Book in Chapter 5.0.3. The understanding of these two is to ensure that any internal law puts a limitation on the capacity of the parties to take up any contract. He characterizes that this limitation shall incapacitate the party to not enforce the arbitral agreement, and therefore shall invalidate the agreement and the jurisdiction. In the case of Iran versus US ICC in 2020, decided that if there are two considerations undertaken by the party, there is no requirement to take up the arbitral agreement. The Iran versus US case had the verbatim arbitral agreement clause and a constitutional clause as well. While in this case, the court did not allow the parties to go ahead with the same, it did hold two major things. Firstly, that there should be disclosure of such limitations, such as Article 75. And secondly, the counsel of the other party should be aware of this. In our case, both of those limitations have been fulfilled. Therefore, the party at the claimant end does know and also was totally aware throughout the procedure. If the tribunal is satisfied with my arguments, I request if I could move to issue number 2. Thank you.
Please do.
Moving to issue number 2. The respondent submits that the tribunal should stay or bifurcate the proceedings on 2 grounds. Firstly, that there is a material facts and investigation against Mr. Field are sufficient. And secondly, that the dismissing of the request for stay or bifurcation would violate public policy of the state of Equatoriana. That's Article 15 of the Anti-Corruption Act, given in the response to the record. Moving to my first argument. The landmark test held by PCA in 2021 in the case of Penville versus Kyrgyzstan indicated a red flag test. The red flag test indicates two major landmark stones. Firstly, that there should be sufficiently clear and convincing arguments. And secondly, the facts underpinning these red flags must be convincingly proven. In our case, we have 4 major highlighted facts. I request the tribunal to reach to C5 at page 16. This is the citizen article panel. Is the tribunal with me? In the last paragraph of this article, it is indicated that there were a major controversial contracts which were awarded by Equatorian Geoscience. Now we shall move to page number 32. That is the statement of Ms. Bourgeois. She was the assistant to Mr. David Fields, the COO of the Equatorian Geoscience. This is at page number 32 panel. Is the panel with me? It indicates 2 major things. Firstly, that there was changes in the credentials of the contract. That is, after coming of Mr. David Fields, the amount of drones increased from 4 to 6. The price was lowered by 20%, and there was increase in the maintenance timing. To add to that, in paragraph number 4, it indicates in the last sentence that the agreement was signed in a beach house in a closed-door negotiation. So nobody but Mr. David Field was part of this negotiation. These facts underline how exactly this agreement had suspicion around this. There was changes in the basic credentials of the contract. And to add to that, I request the tribunal to reach at page number 33, the citizen article again. In the first row, paragraphs which says, according to Ms. Fonseca, that's the third last paragraph. Is the tribunal with me? Is the tribunal with me? It indicates that there were two major payments done by Equatorial Geoscience to Mr. Field's cousin. To add to that, in the very next paragraph, it's indicated that Ms. Fonseca has announced that her team will investigate other two contracts along with this very contract against Mr. David Field. These facts are convincingly enough to show that there were enough evidence against Mr. David Field to proceed with investigation. These facts also show that the preliminary objections raised by respondent are enough to hold red flag test again up by the same court.
Counsel, if I can ask a question here, I haven't quite understood the link between the red flags and your stay application, but you're asking us because the state itself has decided to investigate, the state itself should therefore be entitled to a stay. Am I understanding the logic here? Because Ms. Fonseca, who's been appointed by the state, is going to investigate something that entitles the state to use her appointment as evidence?
Thank you, Mr. Arbitrator. The reasoning why we are giving you these facts against Mr. David Field is to show that in current case, the cases such as that of corruption are not a simple case. Any person who has done corruption will always it will not show his traces back. And this was the holding even in the Penville case last year. I note that my time has elapsed. If I request the tribunal to give me 1 minute extra to answer your question and conclude my proceedings.
Please do.
Thank you, sir. In the Penville case last year, this tribunal held that in a situation where the corruption cases are there, no person who is held guilty would leave any traces back. This indicates that facts in consideration against a person which hold them suspicious or guilty are essentially important to show how his proceedings are important in the domestic courts. And the tribunal should not have the capacity or power to indulge in those same complex proceedings and waste its efficiency and time and money on the same. This holding by the Penville versus Kyrgyzstan case is essentially important to uphold efficiency for the tribunal. And therefore, we nudge the tribunal to take same into consideration again, because the case is very similar where we have corruption allegation against one of the primary witnesses of the agreement.
Thank you. Does that conclude your submissions?
Thank you, sir. I would request 30 seconds to conclude my arguments for both the issues.
Please.
Thank you, sir. The respondent submits that the tribunal must consider the substantial backing for the respondent's objection before granting an award. Proceedings, despite merits of this case, depending on an ongoing investigation which may lead to an unenforceable award being granted due to public policy concerns, would be costly in time, money, and efficiency. And therefore, the respondent requests the tribunal to stay the current proceedings until the investigations have been concluded, or alternatively, bifurcate the proceedings. Thank you so much.
Thank you. May we have Claimant's response on jurisdiction, please?
Thank you. Good afternoon from China, members of this tribunal opposing counsels. My name is Wang Zhiheng, and I will deal with the procedural issues on behalf of Claimant, Zhongnai PLC, in today's proceedings. Members of this tribunal, this case is all about mutual consent. Under the MP Development Program, Respondent concluded a purchase and supply agreement, PSA, for jobs with Arkai. However, 1 year afterwards, Respondent began to have a second chance because the new government of Equatoriana suspended the program. Thus, Respondent now deploys an avoiding and delaying tactic, hides itself under the glass ceiling of the criminal proceedings, trying to escape from its contractual obligations and the arbitration agreement that it has already consented to. It is in this regard, and also to mirror my opposing counsel's arguments, claimant has two submissions to make. First, the tribunal has jurisdiction over this case, and second, this arbitration should not be stayed nor bifurcated. Proceeding to my first submission regarding the tribunal's jurisdiction. My opposing counsel argues that the reason why the tribunal lacks jurisdiction is because respondent lacked the capacity due to lack of parliamentary approval. Claimant admits that in our case, the PSA may be classified an administrative contract under Equatorial Constitution law. However, it is claimant's position that Equatorial law, including the Constitution law, is irrelevant here because it is the Nubian law that governs the arbitration agreement at hand. Members of this tribunal, it is respondent who proposed to arbitrate with our client, and the parties initially, from the very beginning, have selected the seat of arbitration as the Nubia here. This choice of seat has never been reconsidered by the parties. Both parties would intend their choice of law to uphold the validity of the arbitration agreement rather than deny such validity. Here, we suggest the tribunal to follow the validation principle recognized by many cases, like the BCY versus BCZ case addressed by the Singapore High Court, Enka versus Chubb, Kebabji versus Coldfood addressed by the UK Supreme Court in the recent 2 years. Those courts held that when the tribunal finds that there may exist more than one law that may govern the arbitration agreement, they shall select one law that would render the arbitration agreement valid rather than invalid, to protect parties' wish to uphold the validity of the arbitration agreement. And we hereby also can provide a case called Balkan versus Ghana addressed by the PCA tribunal in 2010. In that case, there also exists a parliamentary requirement under Article 181 of the Constitution of Ghana. However, the PCA tribunal there held that the very fact that respondent itself has proposed to settle disputes by arbitration suggests that the arbitration agreement is valid and in force. And the reason why respondent cannot invoke the Constitution law is because it has consented to arbitrate here. And in our case, my opposing counsel argues that the parliamentary approval has already been known about by claimant, and it is essentially important. We also recognize that before concluding the agreement, we already knew that there should exist a parliamentary approval. However, if I may direct the tribunal's attention to page 18 of the record. Page 18. Is the tribunal with me? Thank you. In paragraph 9, starting with later I learned from Mr. Bluntschli, from the bottom line 3, I quote, Mr. Bluntschli told me that he saw no problem in the lacking of parliamentary approval since the minister had assured him that the parliamentary approval was just a formality and would be forthcoming.
Counsel, if I can interrupt here, I understand your argument that about the validation principle, but you've also emphasized that consent is the ultimate question. And what you've just taken us to suggests to me that your client knew that there was an element of consent from Parliament that was required and knew that it didn't get it. How does that then show consent? Whether or not they thought it was a formality, they knew about it. And doesn't that overcome any reliance on the validation principle?
Thank you for your question, Mr. Arbitrator. In our case, we also recognize that objectively, the parliamentary approval shall be expressed based on the formal vote. However, at the time of the contracting, subjectively, neither claimant's employees knew about that there should be an express approval, and it is from claimant's side that an implicit one may suffice. That's why we would trust the authority of the minister that with his approval on the PSA, the arbitration agreement would also be valid.
You just took us to a witness statement that doesn't say that. It says in paragraph 9, where we're on page 18, that
yes,
it was going to be forthcoming, right?
Yes.
That's different from it isn't needed.
Mr. Arbitrator, if I may turn your attention to page 19 of the record. Page 19. Thank you. Paragraph 15. From the bottom, line 3. In the parliamentary debate in June 2021, the main line of argument of the government then was that the minister had authorized contracts with arbitration agreements providing for the transparency rules, explicitly referring to our arbitration agreement at hand. And at the time of the contracting, Claimant thought that the parliamentary approval is essential. However, the minister said that it is just a formality. It is impossible to require Claimant as a foreign party seated in another country to question the authority of a minister of another country. Specifically, as we did not know that the parliamentary approval must be an express one based on a formal vote. When the Parliament of Equatoriana did not raise any objections to our arbitration agreement on this parliamentary debate, it is from our side that the arbitration agreement was validly concluded between the parties. Thus, the tribunal has jurisdiction over this case. With no further questions, counsel will move on to the second submission. That is, this arbitration shall not be stayed nor bifurcated. The first reason concerns the existence of corruption argued by my opposing counsel. My opposing counsel raised, namely, 4 red flags trying to prove the existence of corruption. However, my opposing counsel failed to prove that the offshore accounts were used by Mr. Blanchley to transfer the payments to cause undue influence to the transaction to Mr. Field. Members of the tribunal, if I may again direct your attention to page 49 of the record. Page 49. Is the tribunal with me? Thank you. Paragraph 40. This question concerns the 2 offshore accounts of Mr. Blanchley, and in line 4. From one of the accounts, larger sums had been transferred to 3 other offshore accounts, the owners of which are not known. And neither is the origin of the money known. Thus, my opposing counsel failed to prove that the offshore accounts were owned by Mr. Blanchley and transferred the money to Mr. Field. My opposing counsel also raises suspicion regarding the pricing structure changes regarding the PSA. However, the reasons why the parties concluded the now PSA in Mr. Blanchley's email, the reasons are very clear. That is because, first, we could reuse the 3 nearly finished UAVs from our previous customer. And second, a respondent's willingness to structuring the service elements of the contract differently. In page 33, respondent's CEO and the minister have also confirmed that the offer provided by Claimant was very excellent and favorable. That's why they increased the number of the UAV by 2. Thus, it is our position that my opposing counsel failed to raise clear and convincing evidence to prove the existence of corruption, rendering no need of this tribunal to stay nor bifurcate this arbitration. Our second reason concerns our submission is that the tribunal, in fact, has the power and is more neutral to decide on corruption issues in our case. My opposing counsel argues that the corruption issues are quite startling and they can only be decided by the national authorities of Equatoriana. However, the corruption issue in our case specifically concerns the validity of the contract, the termination of the contract. This is a matter different than the conviction of accused persons of violating criminal laws. The tribunal does not have to deal with the criminal liability of the persons, but just decide on the validity of the contract, whether it is tainted by corruption. Specifically, this tribunal is more neutral to decide on this issue because there exists a serious bias and personal stake in the criminal authorities of Equatoriana. Members of this tribunal, Ms. Fonseca, the nominated prosecutor and the new head of the prosecution office, are vocal critics of the corruption within the old government. Moreover, Ms. Fonseca's brother-in-law has been the CEO of the other bidder in the tender process. And Ms. Fonseca's son's fiancée, Ms. Bourgeois, had been the former assistant of Mr. Field, and the two persons even work in the same office in respondent's premises. As there exists a serious bias and the parties indeed choose the seat of arbitration as Danubia, a neutral seat, they value neutrality. We suggest the tribunal to decide the corruption issues here. And the third reason concerning to reject my opposing counsel's arguments is that stay or bifurcation would violate the tribunal's duty of procedure economy. Article 17, paragraph 1 of the PCA rules empowers the tribunal to conduct the arbitration as it considers appropriate and avoiding any unnecessary delays and expense. This ensures the tribunal's discretion to reject stay or bifurcation whenever it is unnecessary and requires the tribunal to conduct the arbitration expeditiously. And in our case, a stay or bifurcation would cause irreparable harm to claimant as a small company. The criminal investigation will not be concluded by the end of 2023, while the PSA had already been suspended due to respondents' unilateral speculation of corruption since the end of 2021. Claimant here is only a medium-sized producer with its annual output is 5 drums, while the PSA concerns a sale of 6 drums. Thus, a stay or bifurcation would cause irreparable harm to claimant in the severe trade winter of the COVID-19 pandemic. Thus, we suggest the tribunal to not stay nor bifurcate this arbitration. With no further questions, counsel would like to conclude. To conclude, the tribunal's clear jurisdiction has been firmly established, and this arbitration shall neither be stayed nor bifurcated. Respondents' persists of tactics to delay and frustrate this arbitration shall be dismissed. Unless I can further assist this tribunal, this concludes my submissions. Thank you.
Thank you very much, Ms. Wang. We move now to the question of merits. Would claimant like to proceed?
Presiding arbitrator, before arguing the merits, there is probably a rebuttal and rebuttal part of the procedural issue.
My apologies. We had not allowed the time for that. How long would each party like for rebuttal and surrebuttal?
We'd like 1 minute for the rebuttals.
That sounds fine to me.
All right. Members of the tribunal, the rebuttal is based on the jurisdictional aspect. The seat of arbitration in the current case will not be the seat of Danubia on 2 grounds. Firstly, the PSA signifies in Article 20, Clause D, that Equatoria is the law governing the agreement in the current case. There is no other definition or mentioning of whether arbitration agreement will be dealt separately. And therefore, in that consideration, we should understand the arbitral agreement part under New York Convention because the parties are signatories to it. Under Article 5, Clause 1, it understands the jurisdiction of a party to be that of the incorporating state. In the current state, it will be the state of Equatoriana, as it is the state of incorporation of the company, and therefore the law of Equatoriana will be applicable on the Equatorian on the parties in the current case for the arbitration's purpose. Thank you.
Thank you. Is there a rebuttal?
Yes. For surrebuttal, claimant has 1 point to make. The seat of arbitration is indeed Danubia, and it is respondent who first proposed the seat to be Danubia due to the bad reputations of the courts of Equatoriana. According to Article 18 of the PCA rules, the seat of arbitration shall be the parties have chosen, here, Danubia. And according to Article 23, Paragraph 1 of the PCA rules, the separability principle shall be recognized by this tribunal to treat the arbitration agreement as an independent agreement from the main contract. Still, the seat of arbitration as Danubia, leading to the application of the Danubian law to govern the arbitration agreement. And even if, and we also admit with my opposing counsel that Article 5.1a of the New York Convention may provide significant guidance on this issue. This concludes my rebuttal. Thank you.
Thank you very much. So we'll now come to the merits for claimant.
Yes, presiding arbitrator. Thank you, presiding arbitrator and members of the tribunal. My name is Wang Wenchen, and I will address the merits issue of claimant. Claimant has engaged in this negotiation in the genuine belief that the parties have established a relationship of trust and confidence. However, intended to avoid the domestic political influence, Respondent attempts to utilize the ICCA as a shield to escape its contractual obligation. To achieve its intention, Respondent incorrectly classified Castro I as an aircraft under Article 2E of the CISG and conformity and misrepresentation issues. Thus, claimant has 2 points to make. First, the agreement should be governed by the CISG. Second, Respondent cannot rely on Article 3.2.5 of the ICCA to avoid the agreement. Moving to my first submission, the agreement should be governed by the CISG. Both Mediterranean and Equatorial are contracting state of the CISG. According to Article 1 of this convention, the CISG apply automatically, and the parties have not excluded the application of the CISG. Respondent argued that the Castro I 2010 is not the aircraft under Article 2E of the CISG. However, the Castro I does not fulfill the necessary transportation function of the aircraft. The aircraft under the CISG refers to an aerial vehicle that is used to transport humans or cargoes. For example, in the motorboat case, the court held that if a boat is classified as a yacht, which is used for pleasure, cruising, or racing other than transporting, it will not be considered a ship under the CISG. Likewise, a vehicle that can fly but does not have a transportation function is not an aircraft. Claimant wanted to emphasize that when we apply the transportation function as a criterion, it only refers to the principal function, but not extended functions. For example, a UAV like the Dajiang UAV, which is used for taking photos, although it has some transportation function, but its principal function is taking photo. That's why it is classified as a camera, but not a transportation vehicle by the World Customs Organization of International Trade. It is indeed the present case, because the Castro I in the present case can at most have an extended use of transportation. May I draw the tribunal's attention to page 9 of the record? Page 9. Is the tribunal with me? Thank you. In the paragraph starting with product, I quote, "For state-of-the-art unmanned vehicle systems for the collection geological and geophysical data necessary for the exploration and subsequent exploitation of the expected natural resources." So we can see that the UAS respondent needed is used for collecting the necessary data, which is the surveillance purpose, but not the transportation purpose. And according to its surveillance purpose, claimant provided the Castro I, which fulfills all of the surveillance purpose instead of the transportation purpose of respondent. And it is because this advanced surveillance purpose that respondent concluded agreement with claimant. Respondent find it very strange that the Minister of Equatoriana mentioned the past unusual transportation use in his speech, because only in truly exceptional circumstances of emergency and no other means of transportation was available will catch-your eye be used for transportation. And before transporting, the surveillance equipment should be removed from the catch-your eye at first, and its transportation distance would be limited to line-of-sight flights, as the communication link is via radio. Thus, it is an extremely unusual, inconvenient, and insignificant use of the catch-your eye. It could at most constitute the extended function. If respondent aimed at this function, it could simply choose a cheaper cargo UAVs with larger payload base instead of the catch-your eye. It is just like no one would choose an expensive leather fur coat to mop the floor. And why the minister mentioned this insignificant use, may I draw the tribunal's attention to page 46 of the record. Page 46. Is the tribunal with me? Thank you. This is the procedure order number 2 in paragraph 22. Line 5, I quote that Mr. Field has never made clear to the minister that these were truly exceptional cases and the cheaper alternatives would have been available for such tests. Thus, the minister has not realized that it is just an extended use of the catch-your eye, and it is just an excuse for respondent to explain the increase of additional 2 catch-your eye instead of an objective description.
Counsel, I have 2 questions on this. One is, are we meant to ignore the language in the contract itself, which calls it an aircraft? You skipped over that when you described it, and I'm just wondering, and I'm not saying we have to rely on that, but it does call it an aircraft. And then second, are you telling us that because your client misrepresented the capacity of what this vehicle could do, or this I don't want to use the word aircraft, but that's what the contract says, this aircraft could do, that somehow justifies defining it in a way that's convenient for your client now?
Thank you, Mr. Arbitrator. For the first questions, the agreement, although there was an expression of aircraft which was stipulated in the agreement, claimant submits that because respondent is a not professional entity in drums, and the agreement was drafted by respondent, such wording like the aircraft was absolutely a misunderstanding of the relationship between drums and aircraft. And both claimant and respondent knew deeply that the product in this transaction refers to drums, which focuses on data collecting, but not the transportation function. And for your second question, respondent accused us of misrepresentation of our product. However, that is not a misrepresentation because the catch-your eye is indeed our newest product when concluding the agreement on the market. And
that's not the representation I'm talking about. You were saying that you were describing the capacity to transport things as the way you described it, something that was done for political expediency. And what I was hearing you say is, yes, your client went along with a misrepresentation because it was convenient to help the minister, but that your client knew that that was not a fair representation of what the vehicle did.
Thank you, Mr. Arbitrator. Although the catch-your eye could be used for transport and it has the capacity to transport, as I just mentioned, it could at most constitute an extended use. We could not use the extended use to classify if a product is an aircraft, because most of the vehicle in our daily life have their transportation function in truly exceptional circumstances. We only could apply the principal function, which is the surveillance purpose of the catch-your eye, to define if it is an aircraft under the CSG. That's why claimant submits that it is not an aircraft and the CSG should apply to the agreement. I hope this answers your question.
Thank you.
Thank you. And with not further question, claimant will move on to the second submission, which is respondent cannot rely on Article 3.2.5 of the ICCA to avoid the agreement. Here, claimant has 2 points to make. First, the CISG preempts the ICCA to govern the dispute. Respondent's claims for misrepresentation is actually a breach of contract claim in masquerade. According to the Siloda case, if one party's misrepresentation stems from its representation of the party's agreement, there is an issue of breach of contract, which should be governed by the CISG. And in the present case, respondent's claims for misrepresentation exactly stem from its incorrect understanding of Article 2A of the agreement. This kind of claim was contractual and should be governed by the CISG. Respondent cannot rely on its domestic law to avoid the agreement. And moving to the second submission on this point, claimant submits that even if the ICCA applies, claimant has not constituted fraudulent representation or fraudulent non-disclosure. A fraudulent representation requires deliberate misrepresentation and a goal to gain an advantage to the detriment of the parties. Neither of them existed in the present case, because when concluding the agreement, the castor eye is indeed the newest product on the market. The Hawkeye was still, the development of the Hawkeye was still unfinished, and it was in the test lines. The function of it is unstable. As a responsible company, we cannot provide it to our counterparty. And we haven't gained any advantage to the detriment of respondent, simply because claimant has given respondent a considerable discount, and the castor eye is and the Hawkeye, the size of the Hawkeye is too large, which will impose a disruption of the wildlife in northern Equatoriana. And this will apparently be detrimental to respondent's data collecting activities. Moreover, claimant has not constituted fraudulent non-disclosure because in the present case, the relationship between claimant and respondent is simply buyer and seller, which does not require higher standard of disclosure. In Forrester case, the court held that only when there were fiduciary or other similar relationship of trust between the parties, the seller and buyer will have a duty to disclose anything it knows about environmental contamination. Moreover, the court held that if the information could be get and discovered by reviewing the public records, the information was within the fair and reasonable reach, which did not require a disclosure obligation. It is indeed the present case. It is generally known to the market that claimant is developing a new product, and the relationship between them does not require higher standard of disclosure. That's why claimant submits that claimant has not constituted fraudulent non-disclosure. Respondent may allege that the case which was decided by the Supreme Court of Equatoriana could be applied in the present case. However, it is an old single case which was decided 12 years ago, and it is quite different from the case at hand. First, it was a totally domestic law which shall be governed by the Contract Act, while in our case, the agreement should be governed by the CISG. Second, in that case, the parties continue to negotiating the consequences of misrepresentation in that years. However, in the present case, respondent never mentioned the misrepresentation issues after May 2021 until it suddenly resurfaced in May 2022. That's why claimant submits that even if they have the right to avoid the agreement, it has exceeded the reasonable time. If the tribunal have no more questions, counsel will conclude. Respondent has, thank you. Respondent has teared out the agreement between the parties. It neither performed the agreement nor paid for the damages. Even worse, it incorrectly accused us of misrepresentation. Therefore, we respectfully ask the tribunal to reject any claims for avoiding the agreement and declare that respondent has breached the agreement. That concludes my submission. Thank you.
Thank you very much. Can we hear from respondent, please?
Thank you, Mr. Chair. Just confirming I am clearly audible and visible to everyone. Thank you.
Indeed.
Thank you very much. Members of the tribunal, esteemed colleagues, good afternoon from India. My name is Kavya, and as introduced, I will be dealing with the merits of this case on behalf of Equatoriana Geoscience, the respondent in these proceedings, dealing with the substantive issues of this dispute on the applicability of the CISG to the PSA and on the applicability of the International Commercial Contract Act on these proceedings. In that vein, we have two key submissions. Firstly, that the CISG does not govern the purchase and supply agreement, and secondly, that the respondent is justified in relying upon Article 3.2.5 of the ICCA to avoid the PSA. Moving first to the question of the CISG governing the agreement, we make the following contentions in response to claimant: that the Kestrel 2010 UAVs are aircraft pursuant to Article 2E, and that the subject matter of the PSA does exclude the applicability of the CISG. I shall respond first to claimant's submissions regarding the applicability of the CISG, firstly on the basis of the nature of the drones and the intentions of Article 2E in excluding them, in excluding aircraft, and the relevance of primary and secondary usage, in which we contend that the threshold is capacity for transportation rather than suitability for transportation, as well as the relevance of the criteria of registration requirements differing in this case. We would agree with the claimant that the PSA does fulfill requirements under Articles 1 and 3 of the CISG regarding the international sale of goods, but we do contend that Article 2E explicitly excludes the sale of certain goods, including hovercraft or aircraft, from its scope, and that claimant has failed to consider that transportation is not the sole reasoning behind this distinction being made. And as a result, we make three limbs of argument. Firstly, that the UAVs do fall under the scope of the term aircraft. Secondly, that if the CISG is found to have ambiguity, reliance upon the Equatorian and domestic law would also include UAVs under the scope of the term aircraft, and that this would be applicable. And thirdly, that the registration requirements for the sale of aircraft do not impact its nature for the purposes of application or exclusion of the CISG. Article 2 requires courts or judicial tribunals to determine whether the sale is comparable to the kinds of sales that are excluded from the CISG sphere of application. And we would note that the reasoning behind aircrafts being excluded is that in some jurisdictions, the sale of aircraft is considered to be a sale of immovable property, and the differing requirements in terms of registration leading to a difficulty in terms of applying uniform rules for such sales are what led to its exclusion from the CISG. We would note, however, that these registration requirements of aircraft, despite being a primary reasoning for their exclusion, do not impact the status of Kestrel as an aircraft for the purposes of application. On this, we note that as per Article 10 of the Aviation Safety Act, which is applicable as the choice of law of the parties under Article 20D of the Purchase and Supply Agreement, found on page 10, if the tribunal is with me. We would note, referring to Exhibit R5, in which the Aviation Safety Act is noted on page 36 of the record. Any aircraft owned or operated by a private entity in the territory of Equatoriana shall be registered at the aircraft registry. And in the present case, there is no registration requirement, purely owing to the fact that the respondent is a state-owned entity and thereby is not a private entity operating this machinery. Had the exact same machines been purchased by a private entity, they would be subject to registration. And as per the Aviation Safety Act, this would thereby establish that they have the potential for registration, which by itself would consider the fact that they are excluded from the scope of the CISG, since the CISG does not consider the nature of buyers or of parties, but only the nature of the goods and their potential for registration and meeting the criteria for exclusion. Therefore, the absence of this requirement does not impact the Kestrel's status as an aircraft. But it is important to note that, as Claimant has pointed out, the intended use of the Kestrel's being surveillance, it is still relevant that the UAV has the capacity and has indeed in the past been used to transport cargo. This is also found on page 44 of the record in paragraph 9. And we would also note that this was a quality emphasized by Claimant's Chief Operating Officer, Mr. Blunchley. This is found on page 35 of the record, if the tribunal is with me. We would note, even if this tribunal does find ambiguity around the scope of the term aircraft in the CISG in order to determine whether drones would fall within this scope, since the CISG is to be interpreted in light of its international character, reference to international trade usages and laws surrounding this would be applicable. And here we would note that the term drone is included within the ambit of and used interchangeably with the term aircraft in several jurisdictions, including the United States, India, and the European Union. And however, even if this tribunal finds ambiguity regarding this recognition and perceives a gap in the convention in terms of this definition, we would still fall back on reliance of the Aviation Safety Act. And here we would again lay reliance on Article 1 of the Aviation Safety Act, which it is also noted was amended in 2010, specifically to include unmanned aerial vehicles under its ambit. This is found on page 49 of the record in paragraph 51. If the tribunal is with me. According to Article 1 of the Aviation Safety Act, found on page 36, any vehicle is considered an aircraft if it satisfies any of three conditions. First, that it is used or intended to be used for moving persons or objects, or if the length exceeds 90 centimeters, or if its payload is higher than 50 kilograms. We note that the Kestrel has the capacity to be used to carry cargo and has a payload of 245 kilograms, which is almost a quarter of a metric ton, and thus satisfies two of the three requirements under the Aviation Safety Act. And thereby, by application of the domestic law, which governs the purchase and supply agreement and was mutually agreed by the parties, as was also emphasized by my opposing counsel, the Kestrel 2010 UAVs are aircraft, and consequently, the CISG's application is excluded in the present case. If there are no apologies.
66@gmail.com received one new message read. Final round Zoom link 2/3.
On that note, I do notice my time and seek the tribunal's permission to move to the second substantive issue before us on the applicability of the ICCA to the PSA.
Please do.
Thank you. We submit that the tribunal should reject the claimant's arguments that the International Commercial Contracts Act cannot be applied in this case. This is contended on two main limbs. First, that Article 3.2.5 is applicable to the PSA. And second, that avoidance of the contract would be justified nonetheless. At the outset, I would note that claimant's submission that this misrepresentation is about whether or not the Kestrel's are the newest form of Kestrel is a mischaracterization of the dispute at hand. The misrepresentation being noted here is specifically with regard to technological standing as per industry and market development. And on this, we would note three grounds on which we suggest avoidance is justified. First, that the CISG does not address fraudulent misrepresentation as such, which second, necessitates gap filling in the CISG, for which the ICCA is the applicable law through choice of law of the parties. And thirdly, that nonetheless, the essential elements of fraudulent misrepresentation are fulfilled, and thus respondent is justified in avoiding the contract. We would note that there are various forms of misrepresentation, such as innocent or negligent or fraudulent, and it is this distinction lacking in the CISG, which does not address misrepresentation as such, that makes the CISG unsuitable to address the present issue of misrepresentation. We would note that there is thus need for reliance upon Equatorian and domestic law in the present dispute, due to the specific redress from the CISG not being present. We would note additionally that as per the CISG's consideration for sufficient sphere of application over a scenario, not only must the factual criterion be met in terms of which the CISG must apply to the facts of the case, but also that it must pertain to a matter that is regulated by the CISG, and that in absence of this, Any gaps must be settled in conformity with the principles on which it was based, as per Article 7.2. We note here that claimant has specifically misrepresented the nature of how novel or of how state-of-the-art the Kestrel 2010 models are in relation not only to claimant's existing and developing technology.
Excuse me, counsel, but I think one of our panel has disappeared.
Absolutely. May I stop my timer, Mr. President?
Yes, can we just stop you there,
Absolutely.
freeze your time, and see whether we can retrieve Mr.
Absolutely.
Fernandez?
You are requested to join us through time for a short briefing session and session. Please do contact us.
I don't know who that was. Mansi, can we try and find our missing arbitrator?
So, we've received a mail from Sir. I believe he has some network issues or something is wrong with his technical end.
Okay, so we should proceed. We should proceed,
Yes.
should we?
Blank.
So I'll just check with the team.
Inbox
Please
log.
give me a minute.
0 alert. Unread 0 read. Final round. Final round. I am having a tech problem. I can hear the speaker and my camera is on, but my computer seems to. I am having a tech be frozen and separator. From Asia Pacific this pre-moot separator. From Asia Pacific this pre-moot court less Asia Path Asia. From Asia Pacific separator. I am having a tech problem. I can hear the speaker and my camera is on, but my computer seems to have a tech problem. I can't hear the speaker and my camera is on, but my computer seems to be frozen.
So whoever that is talking seems to say he can hear what's going on. So perhaps we should proceed. What do you think?
So we should then, whatever you think is the best.
All right. So sorry, counsel, to interrupt you, but can you continue your stride, please?
Absolutely. Thank you, Mr. Chair. To pick up from where I left off with respect to misrepresentation being fulfilled in this case, we would note that the specific nature of misrepresentation would be the nature of how state-of-the-art or how novel these models are, and that this is the specific grievance for which respondent claims redressal. We would note that this being a specific cause, it requires specific address by the CISG, and in absence of this, various other measures of gap filling are the appropriate recourse, pointing us directly to Equatorian and domestic law, the choice of law of the parties, and the International Commercial Contracts Act, which applies herein. We note that the choice of law clause having been agreed upon and also emphasized by claimant with respect to mutual consent and its importance here, that the ICCA also fulfills the need for conformity with general principles of international consensus when filling gaps in the CISG by being identical to the UNIDROIT principles and thus reflecting a global standard approach. Even if the tribunal does choose to find that the CISG is the applicable law governing fundamental breach under Article 25, however, we note that parties' intentions with respect to the threshold held sufficient to cause termination must be considered in light of the wording of Article 18, Subclause 2, Subclause C of the Purchase and Supply Agreement, found on page 10. If the tribunal is with me. Apologies, the specific clause would be found on page 12. That's Article 18. The wording used herein is other breaches which deprive buyer of what it is entitled to expect under the agreement. We note that this was drafted by the parties by mutual consent, but differs in the threshold it places for such fundamental breach in derogating from the CISG statement, which is specifically requires substantial detriment to parties. We would note that this demonstrates a clear intention of lessening the standard, and thereby we would still be able to claim redressal under this provision, and that there would still be cause for respondent to note its grievance. And the reasoning for this is provided under our last limb of argument with respect to the fact that there has been fraudulent representation of the nature of the drones in relation to market updates. We note that the claimant's obligations with regard to disclosure of newer technology in light of the agreement to provide quote-unquote state-of-the-art equipment of the latest and newest technology, as per their statements and assurances, as well as per the CISG, as per the purchase and supply agreement between the parties, which specifically requires state-of-the-art surveillance technology. This would constitute fraudulent non-disclosure in light of the prompt release of the Hawkeye 2020 UAVs very shortly after the conclusion of the purchase and supply agreement in the span of a mere 2 months. And noting that the Hawkeyes are not only suitable, but indeed more useful for the respondent's purposes than the offered drones, we would submit that this does fulfill the essentials under Article 3.2.5. Firstly, we note that fraudulent intent is indicated by party communications, and that the tribunal, in line with Article 8 of the CISG, Clause 1, would have to interpret statements made by each party according to its subjective intention, and that where this cannot be deduced, a reasonable person's understanding is also relevant as per Article 8, Clause 2. In doing this, we would submit that it is evident that the claimant aimed to quell concerns about possibly outdated technology that originated from 2012 and has not been updated since, by making false claims as to the Kestrel's actual standing in terms of state-of-the-art. And in terms of defining the term state-of-the-art, we rely upon the Oxford Dictionary noting a total of technical and scientific knowledge currently available as applied to a product or design. I note that my time is up. If I may seek an extra 1 minute to conclude my submissions.
Yes, please proceed. I got a message that Mr. Finicio is waiting to be readmitted. So could someone make sure they do that?
Mr. Chair, may I pause whilst?
Yes, you just wait.
Absolutely.
Sir, I cannot see him in the waiting room. I'm checking that, but I cannot see any request in the waiting room.
Nicola.Nicolic 66.
Please request him to try again.
Is someone else on the email chain that could follow that?
I gather he's gone.
Unread zero read. Final round. Unread zero read. Final round. I don't have the link to the hearing. I don't have the link to the hearing. Only the link to the room. I don't have the link to the hearing.
Yes, he doesn't have the link. He doesn't have the link to the hearing. He only has a link to our prior discussion. So could the organizers please send him a link to the hearing? We got that in a chat, you might remember. Can you send that to him? And we'll wait for him to join until we ask counsel to conclude.
Right, so give me
I don't have the link to the hearing, only the link to the room we used before. Right. To a bar. Subject. Message bar. To with one add. Other. To with one. Finizio. To with one. Subject edit. Message body frame. Message body document editable. W-E space A-A-B space J-N-T space K-E-T space R-G-A-N-I-Z-A-O-R-O T space Y-O-U L-I-N.
Can someone send him the link to the hearing?
Sir, we are doing that. Please give me a minute. I'm just.
Thank you very much.
Send message dialog. Are you sure you are ready to send this message? Send button.
I'm not sure who this is.
Final round Zoom link.
It's keeping us running commentary. It doesn't sound like Stephen to me.
35.
Some form of artificial intelligence, I suspect.
Two 88. Download.
I've sent the link to him as well.
Thank you.
Sir is joined.
So you're back, Mr. Fenicio. We're just down to a final summary by respondent on the merits. You're muted.
Yeah, and I heard most of the argument. I just lost a little bit of the second
Did you
argument.
have any questions?
Not at this point, no.
Okay, thank you. So counsel, please conclude.
Absolutely. Just confirming I'm clearly audible.
You are.
Thank you. We note in conclusion that the essentials of Article 3.2.5, that is fraudulent intent and either misrepresentation by language or actions or non-disclosure of circumstances that ought to be disclosed as per reasonable commercial standards, are what has been violated in this instance. We rely on suggesting that reasonable commercial efforts of fair dealing would require not only a good faith effort, but also reasonable levels of disclosure, or in terms of efforts to achieve the accomplishment that is sought by both parties. In this event, the purchase and supply agreement for drones in response to respondent's tender. We would additionally contest any of claimant's assertions with respect to the fact that there was any indication in which an indication of the Hawkeyes existing would have been unreasonable. We would note that it is perfectly within reasonable commercial standards for parties to a contract to discuss various goods that a party has, that the seller particularly has, that would fulfill requirements. I do note that my time is up, and on that I will conclude, noting that we request the tribunal to conclude that the CISG not only does not govern the purchase and supply agreement, but also given that the ICCA is applicable, and that the parties chose the agreement to be governed by this law, that the respondent is entitled to avoid the PSA under this provision for misrepresentation with respect to the technology standards of the UAVs in relation to contemporary updates, and that it may seek relief in line with such avoidance. That concludes my submissions, members of the tribunal. Thank you.
Thank you, counsel. Rejoinder?
Counsel for claimant would give a rebuttal in 1 minute to respondent's submission.
Please proceed.
Thank you, Presiding Arbitrator. Respondent submits that Aviation Safety Act of Ecuadoriana could be applied to interpret the aircraft under the CISG. However, this is not right. Article 7 of the CISG clearly stipulates that the interpretation of this convention should emphasize its international character and the need to promote uniformity in its application. Thus, we cannot invoke a single domestic law to interpret the CISG because different countries have different definition of aircraft. This will do harm to promote the uniformity of the application of the CISG. Thus, we cannot apply the domestic law of Ecuadoriana to interpret this international convention. That concludes my rebuttal. Thank you.
So rebuttal?
Thank you, Mr. Chair. Whilst the claimant may have misunderstood respondents noting the ASA as applicable law, we would firstly note on 2 points that this does not stand. Firstly, in terms of the fact that the purchase and supply agreement, which as repeatedly emphasized by the claimant from the very first line of claimant counsel number 1's speech, it was drafted by mutual consent of the parties, specifically outlines the law of Ecuadoriana as applying. Secondly, we would note that whilst we would not suggest that the law of Ecuadoriana be interpreted in order to explain the CISG, we do suggest that as applicable law, if there is ambiguity found within the definition of aircraft, this is the appropriate law to solve it. And it is under the ASA Red alone that drones do classify themselves as aircraft, fulfilling 2 out of 3 separate conditions. Thank you. That concludes our submissions.
Well, thank you very much to all the counsel. This has been a very high standard of mooting. I personally regard myself as privileged to have heard each of your submissions. Thank you very much indeed for that. Hopefully we might, I'll actually be in Vienna, but not Hong Kong. If you're coming to Vienna, it would be great to be able to catch up. It remains, I think, on my part, to wish you well as you prepare for and compete in Hong Kong and or Vienna. I would invite my other panel members to make any comments that they would wish to make.
I would like to echo Professor Jones. It was a very high standard, and I wish both teams the best of luck, and am available for feedback or hopefully to get a chance to see you in person if you were in Vienna.
I enjoyed it very much. Thank you very much. And good luck with what happens next.
Sorry. I would echo all of that. And if you're coming to Hong Kong, very much looking forward to seeing you.
It was also my great pleasure to be with you. The standard was really high. I wish you all the best with further competitions. And as someone who has a disability and who is in the world of arbitration, I know how it is difficult to go forward and to fight for your place and to become visible in our community. That's why I once again wish you all the best and hope to meet you in Vienna.
Well, thank you very much. The tribunal will now confer and you will be advised separately of the outcome of the competition. Is it possible to put the tribunal in a breakout room?
Yes, sir. Thank you so much, everyone. The tribunal will now be put in a breakout room. All the participants are requested to please wait till 6:30 p.m. IST. The results would be announced in the closing ceremony. Thank you and have a great day.
Thank you so much, everyone.
Bye.
Thank you, members of the tribunal opposing counsels. Have a nice day.
Thank you.
Thank you so much.
Bye.
Hi, Mansi, just confirming, can we leave?
I'm sorry?
Oh, so sorry. I was just asking the OC if we can leave the meeting.
Oh.
You transfer us directly to the breakout room, or